The problem is in the remedy for copyright. As it stands now, small creators who have seen their work used without permission or just outright stolen have had one path for relief, filing a lawsuit in U.S. federal court. Of course, the reality is that path is no path at all. Nobody is going to sue in federal court over an infringement that averages well under $3,000. The math simply works against most creators. And let's remember, it doesn't have to be big money to make a big difference. A $500 or $1,200 infringement can be the difference in paying the mortgage or health care or food on the table or the first family vacation in 5 years.
As an independent creator, I appreciate and believe in the idea of copyright. I always retain my copyright in my contracts with clients. At the same time, I do not routinely register my works. I consider myself an intermittent registerer. I would, however, register my images more regularly if given a streamlined, reliable, and affordable path for pursuing infringement. Copyright registration is an investment in time and money, and yet, with the present situation, it is rare that there is a positive return on that investment.
The bill also provides that the CCB cannot award a total of more than $30,000 in damages in any one case, which is very different than federal law, where there is no cap at all. The availability of these statutory damages is essential, given the difficulties of proving actual damages to limited discovery rules and the fact that most parties will not be represented by counsel. The CASE Act is a legislative priority for hundreds of thousands of photographers, illustrators, graphic artists, songwriters, and authors, as well as a new generation of creators, including bloggers and YouTubers across the country. Today they have rights but no remedies. The CASE Act will go a long way to restoring their faith in the copyright system.
There is fair use issues, and I'm concerned about how that will be addressed in the proposed board. And I'll just give a personal example. My daughter has twins, and the twins and my son-in-law were at a restaurant, and music came on, and they were 18 months, and they were dancing to the music. It was really cute. And my daughter posted it because it was adorable, and Facebook took it down because the music was in the background. Well, that was fair use. I mean, it was a 15-second little thing with the cute babies and my son-in-law. But that is fair use, and there is a role for fair use. How are we going to ensure that those findings in the board without an appellate provision is consistent with what is being, because fair use is a judicial doctrine. How do we keep the fair use judicial doctrine in play with the Copyright Board when it hasn't actually, there's no appeal from it?
If I had an avenue where I could reasonably expect the process, what was going to happen, I could understand where that investment was, I would register more frequently. I basically consider myself to register on principle because I want to believe that it's right and that it works. But in all honesty, for me, it does not.
One of the characteristics of IP troll litigation is the extensive use of proxies, assignees, and other shell entities to avoid identifying the real party in interest. And so while we think that's a step forward, some provision that would strengthen that the prohibition so that the real party in interest cannot be disguised, so that the cap could not be circumvented by assignment or other use of proxies would be an important change.
So imagine, if you will, a grandmother who is living in Boca Raton, and she supplements her retirement income by embroidering versions of iconic photos onto pillows, and she sells them, and that's a business that she uses, again, to supplement her retirement income. If the bill is opt-out, as it's currently drafted, the provision that you're referring to doesn't help her if, through the opt-out process, she doesn't understand what's being put in front of her. She gets a letter from a board that she's never heard of in Washington, D.C. She thinks maybe it's a scam or just ignores it altogether. She ignores the second notice, and then months later she finds herself on the wrong end of a $30,000 judgment against her that she doesn't have an adequate way of appealing in a Title III court.
Some of us are really just tired of hypotheticals, because in this room today, there is not a hypothetical. There's Ms. Close. How many of you in here are creators in this room who come here to support it? These are not hypotheticals. These are real people who have real issues with real infringement on their work. And for us to come back and to find a solution so that they can have a place that they can have a regress, where they can have a remedy, where they can have something, we're always going to find, and one of the things that's great in Washington, D.C. is we'll always find the hypothetical that says you can't. I'm about finding hypotheticals that says those that create mean something, and those that create have value and have infinite worth. And we need to make sure that we protect all sides, but also if we ever get to the time to where the hypothetical wins out over the creator, then the creator is dead.
And companies that I respect, Pinterest, for instance, as an example, has what will be called by some a contract of adhesion, right? To participate in Pinterest, you basically have to acknowledge that if you're unable to resolve a dispute informally, we agree to resolve any claim, dispute, or controversy arising out of or in connection with related to the terms through binding arbitration. And so I guess what I'm concerned about is I get all of this due process language, and it sounds flowery and it's beautiful. But with respect to many of the companies that you represent, you have these contracts of adhesion where the same internet users that you're saying you're here before the committee to defend are waiving their rights to participate in the Article III federal court system. So it becomes a little difficult, I think, for many of us to take some of these concerns as seriously as they're being projected. Because at the end of the day, what we're really fundamentally talking about is that you have a situation that's been set up consistent with the United States Constitution, Article I, Section 8, Clause 8, which talks about promoting the progress of science and useful arts, which includes visual artists and photographers and authors and others, who the founders understood was important for them to have a right to vindicate that should be allowing them to benefit from the fruits of their labor and therefore share it. I would just ask the gentleman for 30 seconds.
I'm afraid they're going to call votes in just a moment. If you could wrap it up in 10, I'd appreciate it.
Okay, so let me just simply say that all we're trying to do here is you have a notice and takedown remedy that's inefficient, that's not working on the one hand, and you have an Article III court system that's out of reach. And we're just trying to provide the creative middle class, small business women and men throughout America, consistent with the United States Constitution, the ability to pursue the rights that they have been granted. I yield back.
Thank the
So as the
court.
copyright owner of that work, I would want to enter a level playing field with somebody regardless of whether I had registered my copyright before they infringed on it or not. However, a secondary thing that I appreciate and that I hope that this bill would do is that ultimately I would like everybody to register their copyrights. And I would like also the people who may non-willfully infringe, people who innocently do it, because those people are out there, to be educated about what that means, because ultimately the bigger picture of this is that there's a cultural shift. The root cause of the problem is not being able to enforce the registration and the rights that we are provided.
The reality is, for the internet, they need constructive notice, and we in Congress need to find what that constructive notice. I am sorry that I cannot do a second round for the many people here to ask. With that, we stand adjourned.